Get ready for a legal dictation. 5 seconds. Start. Thus, at the surface it appears, the Supreme Court had principally reasoned, unless there existed a specific exercise of power made by the competent authority to assign the function of adjudication, no function jurisdiction could have been assigned oblique subdelegated in favor of the Commissioner of Customs (preventive) or the Additional Director General, Directorate of Revenue Intelligence, full stop. At the same time, it cannot be accepted as the true reasoning of the aforesaid decisions, full stop. In fact, in those decisions, issue had arisen whether the Commissioner of Customs (preventive) Additional Director General, Directorate of Revenue Intelligence were officers falling within the class of officers of customs defined under Section 3 of the Customs Act, and whether there was any notification issued under Section 6 of the Customs Act assigning any function to those officers, full stop. Paragraph change. Though any officer other than the person of the customs could be appointed as a custom officer by virtue of Section 4 of the Customs Act, such an officer could not hold any function jurisdiction in his favor unless a specific entrustment subdelegation were first made in his favor by issuance of a notification under Section 6 of the Act, full stop. Therefore, the Commissioner of Customs (preventive) and the Additional Director General, Directorate of Revenue Intelligence, though became customs officers by virtue of notification dated 2/5/2012, read with earlier notification dated 7/3/2002 at, in the absence of any further notification issued under Section 6, it was reasoned they could not act as a proper officer to adjudicate a dispute under Section 28 of the Customs Act, 1962, full stop. Paragraph change. Similarly, in the context of the Act, any officer of the central government who may become an officer under Act by virtue of his appointment thus made, under Section 4 (1) of the Act, would remain dependent on a further notification that may be issued under Section 6 of the Act, regarding function assignment subdelegation made in his favor, by the state government, before he may act as a proper officer, under Act, full stop. However, that requirement and condition of law would not attach to an officer of the state tax, full stop. As noted above, undisputedly, the respondent deputy commissioner is an officer of the state tax whose function assignment has been made in terms of Section 2 (91), read with Sections 4 (2) and 5 (3) of the Act, by virtue of Office Order dated 1/7/2017, read with further Office Order dated 19/11/2018, full stop. Paragraph change. Thus, similar to the two methods of function assignment delegation prescribed under the Customs Act, under the Act as well, there exist two different methods to create function assignment delegation in favor of officers of state tax and officers of central tax that is, officers appointed under Central Act full stop. As noted above, function assignment jurisdiction in favor of officers of the state tax may be created by the Commissioner by issuing an order communication in exercise of his powers of subdelegation vested under Section 5 (3) of the Act, full stop.